Hello viewers, so welcome to my channel. I'm Hasham. So in this video I'm going to explain you about the remuneration to directors and managing director. So far in the earlier videos I have completed the meaning, the definition of director, then what is the position of director, qualification, disqualification of director, appointment and removal of director, then duties, liabilities of director, loans to directors. All these things I have explained in the last videos. So if you have not watched the earlier videos, I suggest you to go to the playlist of my channel. Select the subject business law. In that you will find the videos of companies management of companies. So select the topic of management of companies and watch the earlier videos. Definitely you will get a good command on the position of directors. So now in this video I'm going to explain you about remuneration to directors. Watch the video till the end. It's very important. Very frequently it may be asked in examination. So what is the limits given by Companies Act 2013 regarding the remuneration payable to directors? So there is a ceiling. There are provisions to how much remuneration should be paid. First of all, I'm explaining about the overall remuneration, total remuneration. What is the maximum ceiling that is applied when remuneration is paid to directors? So section 197, subsection 1 provides that the total managerial remuneration payable by a public company to its director. This section 197 subsection 1 gives the overall limit, the total maximum remuneration which can be paid to directors of a public company, including managing director and whole-time director. Who is the managing director? After this discussion, I'll explain you about managing director. So including whole-time director and managing director, in respect of any financial year, shall not exceed 11% of net profits of the company. So this point you have to remember. The maximum limit is 11% of the net profits of the company. Again I repeat, according to section 197 subsection 1 of the Companies Act 2013 provides that the total remuneration payable to all the directors, including managing director and whole-time director of a public company, for a particular financial year, for any financial year, shall not exceed 11% of the net profits of the company. Right? Then the company in general meeting may, with the approval of the central government, authorize the payment of remuneration exceeding 11% of net profit. If a company wants to pay the director's remuneration more than 11%, also there is a possibility. The company must authorize in a general meeting. A resolution should be passed in the general meeting that the company wants to pay the director's remuneration in excess of 11%. The company can pay, provided the approval should be received from the central government. The company has to apply to the central government that our company wants to pay the director's remuneration more than 11%. If the central government approves, then the company will have the power. The company must convene a general meeting. In that general meeting, one resolution should be passed that the company wants to pay remuneration more than 11%. In that case, the company can pay more than 11%. Otherwise, without receiving the approval of the central government, without passing a resolution in general meeting, the company cannot pay more than 11% of the net profits. Now, if any director draws or receives directly or indirectly by way of remuneration any such sum in excess of the limit prescribed or without prior sanction of the central government, where it is required, he shall refund such sums to the company, and until such sums are refunded, hold it in the trust for the company. Now, what the provision of the Companies Act says, if a particular director has received a sum of money which is in excess of the limit, then that director must hold that money and return back that excess money to the company. Otherwise, if you have not refunded, then he have to keep it in the form of a trust. That means should keep the money in the form of a trust. Later on, it should be refunded to the company. In simple words, if any director has received directly or indirectly more sum of money in relation to the maximum limit, over the maximum limit, then he should refund that sum to the back to the company. Otherwise, if he have not returned, he should keep it in the trust for the company. This is the overall limit. So what I have explained, the overall limit of the managerial remuneration. So section 197 subsection 1 says overall limit is 11% of the net profit to all the directors, including the managing director and whole-time director for a particular financial year. More than 11% company can pay provided approval of the central government is received and a resolution is passed in the general meeting. Now next topic is remuneration to managing director and whole-time director. So what is the limit on the remuneration payable to managing director and whole-time director? Again, limit is there. The remuneration payable to any one managing director or whole-time director or manager shall not exceed 5% of the net profits of the company. For example, if a company is having one managing director, his maximum remuneration is 5% of the net profits of the company. Suppose if a company is having only one whole-time director, so his remuneration should not exceed 5%. If a company is having a manager, then the maximum remuneration payable to the manager, 5% of the net profit. So if there is only one managing director or one whole-time director or one manager, the maximum remuneration payable to that director will be 5%, not more than 5%. If there are more than one whole-time directors, then remuneration shall not exceed 10% of net profits to all such directors and managers taken together. Suppose if in a company more than one whole-time directors are there, then the total remuneration payable to all whole-time directors should not exceed 10%. So this is the limit given to managing director and whole-time director. Again I repeat, if in a company only one managing director is there, or only one whole-time director is there, or only one manager is there, the maximum remuneration allowed is only 5% of the net profit of the company. That's it. Secondly, if a company is having more than one whole-time directors, then the total remuneration payable to all whole-time directors should not exceed 10% of the net profit. Next one, remuneration payable to directors, other directors. Other directors means not the whole managing director or not the whole-time director. Excluding managing director and whole-time director, other directors are there. So what is the remuneration limit for other directors? The remuneration payable to directors who are neither managing director nor whole-time director shall not exceed 1% of net profits if there is a managing director and whole-time director. Suppose in a company A, B, C, D, E, 5 directors are there. In these 5 directors, E is the managing director. Whereas A, B, C, D are the non-managing director, other directors. Then limit says the total managerial remuneration payable to other directors other than whole-time and managing director should not exceed 1%. If there is any one whole-time or managing director. So in a company, 5 directors, 1 managing director and 4 other directors. The total managerial remuneration payable to 4 other directors should not exceed 1%. Otherwise, in other cases, it shall not exceed 3% of net profit. Suppose, if in a company there is no managing director, no whole-time directors, all general directors. The company does not have a managing director, the company does not have a whole-time director, only non-managing directors. In that case, the limit is 3% of net profit of the company. Next one, remuneration when there is no profits at all. If the company does not have profits or inadequate profits, then what the loss is? Because so far we have seen the overall limit is 11% of net profit. The remuneration payable to managing director is 5% if there is only one managing director. If there are more than one whole-time directors, 10% of net profit. So all the remuneration is based on net profit. Now the case where the company does not have profit or inadequate profit, then how much remuneration should be paid? The loss is, no remuneration should be paid to any director, whether it is whole-time director or managing director. No remuneration should be paid if there is no profit or inadequate profit. Fees will be paid. Director's fees is different from director's remuneration. The director's fees can be paid, but director's remuneration cannot be paid if there is no profit or inadequate profit. So section 197 subsection 3 states, provide that in any financial year a company has no profits or inadequate profits are inadequate, the company shall not pay to its directors, including managing director or whole-time director, by way of remuneration any sum exclusive of any fees payable. That means director's fees can be payable, but director's remuneration should not be payable to any of the director, whether he is a managing director or whole-time. No director's remuneration will be payable, but remuneration may be payable in such a situation in accordance with provisions of Schedule 5. In Companies Act 2013, Schedule 5 is given. Now the law says, if there is inadequate profit or no profit, then remuneration for directors can be paid according to the provisions of Schedule number 5. Schedule number 5. If it is not able to comply with Schedule number 5, suppose if the company is unable to comply Schedule number 5, in that case, approval from the central government must be taken. The company must apply to the central government that we don't have profits, we are having inadequate profits, we are not in a position to pay remuneration to directors. We ask the central government to give the permission. If the central government gives the permission, okay, you pay remuneration to directors, then the company can be able to pay. So if there is no profit or inadequate profit, without obtaining the central government's approval, the company cannot pay directors remuneration. That's it. Now sitting fees, directors sitting fee. Time to time there will be meeting of directors, board meeting, board of directors meeting. So for attending board meeting, some sitting fees will be paid by the company. The company will pay sitting fees to the directors. So again, Companies Act has given a provision regarding the limit of sitting fees. A director may receive fee for attending meetings of the board or committee thereof or any other purpose whatsoever as the case decided by the board. Such fees shall not exceed 1 lakh rupees per meeting of the board. 1 lakh rupees is the limit, not more than 1 lakh. The company can be able to pay sitting fees to any director of the company, maximum limit of rupees 1 lakh, not more than 1 lakh per meeting. Now the independent directors and women directors may receive the fees not less than the fee payable to other directors. That means the Companies Act has not made any difference between independent directors, women directors or other directors. So even if the director is a women director or an independent director, the fees, sitting fees payable will be same as that of other directors. What is the limit? 1 lakh rupees per meeting. Now next one is professional fee. Sometimes a director may provide professional service to the company. Sometimes a director will provide professional service to the company. In that case, the Companies Act says professional fees will be paid to the director, because apart from the director, he is a professional. He is giving professional service to the company. So any remuneration for service rendered by any such director in other capacity shall not be included if the services rendered are of professional service. That means professional services, amount paid for professional services to the director should not be included in director's remuneration, because the director is working in another capacity. What is the other capacity? He is a professional. He is providing professional service. So whatever fees paid for professional service will not be included in director's remuneration. The director possesses the requisite qualification for the practice of the profession. Next one is periodicity of payment. How the payment to directors will be made. So Companies Act says the payment can be made monthly, or the payment can be made depending on the profits. Section 197 subsection 6 provides that a director may be paid remuneration either by way of monthly payment. Monthly payment can be paid by the company to the director, or at a specified percentage of net profits of the company. Specified percentage of net profit for the company, when the profit will be calculated at the end of the year. So at the end of the year, when all accounts are closed, financial statements are prepared, calculate the profit, and as a percentage of profit we calculate manager's remuneration, director's remuneration, and that will be paid. So the Companies Act has left it to the companies. You pay the remuneration to directors either on monthly basis, or you can pay as a percentage of net profit, or you can pay, the Companies Act says to the company, or you can pay partly monthly basis and partly as a specified percentage of net profit. That's all. Now the last point is insurance premium. Insurance premium. Section 197 subsection 13 provides that where insurance is taken by a company on behalf of its MD, managing director, or whole-time director. Sometimes a company will take an insurance policy on behalf of managing director or whole-time director, and the company has paid the insurance premium. The company has taken an insurance policy on MD or whole-time director, and company has paid the insurance premium. Why the company has taken insurance policy? Here purpose is given for indemnifying any of them against such liability in respect of negligence. For indemnifying that party. Who is that party? Managing director. Suppose if there is a negligence on the part of managing director or whole-time director, or misfeasance, or breach of trust, or breach of duty, if these cases had happened with the managing director and loss occurred to the company, then the managing director must indemnify the company. Suppose Mr. X is the managing director. The company has taken an insurance policy in the name of Mr. X. Why? Because if X happens to be negligent, or breach of trust, or breach of duty, then they have to indemnify to the company. In that case, the company will indemnify that party if there is insurance policy, then for which they may be guilty in relation to the company. The premium paid on such insurance shall not be treated as part of remuneration payable to such director. That premium paid by the company shall not be treated as a part of managerial remuneration. Shall not be treated. So Mr. X, suppose Mr. X was found as negligent or breach of duty he has done. There is a loss to the company for rupees 1 lakh. The company incurred a loss of rupees 1 lakh due to the negligence of Mr. X, managing director. Now the insurance amount will be received and indemnified. So instead of amount will be paid by Mr. X, the insurance premium, insurance policy amount will be paid to the company. In that case, whatever insurance premium paid by the company will not be treated as a part of director's remuneration, managerial remuneration. If such person is proved guilty, then definitely the insurance premium paid will be treated as a part of director's remuneration. If the person has proved guilty, then insurance premium paid will be treated as a part of remuneration, otherwise not. So these are the provisions regarding directors' remuneration payable to directors. So what I have explained, the limit, the overall limit, 11% is the overall limit, 11% of the net profit to all the directors, including managing director, whole-time director, right? If the company wants to pay more than 11%, they have to take the approval from the central government and pass a resolution in the ordinary meeting. In that case, the company can be able to make payment more than 11% also. And if a director has taken excess money over the limit, then the director must return back to the company, otherwise he has to hold it in a trust. Next one, we have seen remuneration to managing director or whole-time director. If there is only one managing director, the maximum remuneration is 5%. If there are more than one whole-time directors, overall remuneration of all the whole-time directors should not exceed 10%. Other directors, 1%, 3%, all these things I have explained. So this is the end of the part remuneration to directors. So we have discussed about the remuneration to directors. Now in this video, the last topic is regarding managing director. So in examination, very frequently they may ask you a short question on explain about managing director. So here now I am going to explain you managing director. A managing director is also one of the director, but who is given the substantial powers in the management of the company. So a director who is assigned, who is given, conferred a substantial powers to manage the company is called a managing director. So here a managing director is the director who is entrusted with the substantial powers of management of affairs of the company. So the substantial power of management may be conferred upon as a director in various ways. So how these substantial powers will be conferred on a particular director? Through different methods, through different ways. So what are the methods through which a director will be conferred with substantial powers of management? So different ways are by an agreement with the company. That means that there will be an agreement with the manager and the company. So with the help of that agreement, the director is having substantial powers. Or by resolution of the company. The company has passed a resolution that we appoint a director as a managing director and entrust substantial powers in the hands of that director. So similarly, by a resolution by board of directors, sometimes a managing director will be given the powers through the resolution passed by board of directors or by company's MOA or AOA. Or the company has specified in the memorandum of association or article of association that one of the director will be selected as managing director and he will be entrusted with substantial powers to manage the affairs of the company. A managing director occupies a dual capacity. So a managing director is working under two capacities. First of all, he is a director and also he is an employee. He is a manager. So in two capacities he is working. He is a director and also he is a manager. If the managing director ceases to be a director, automatically he ceases to be a managing director. Suppose if the managing director is disqualified from being a director, so automatically he will vacate the office of managing director also. Now appointment of MD, managing director. How the managing director will be appointed? Few points I am going to explain you. First, no company shall appoint or reappoint any person as its managing director or whole-time director or manager for a term exceeding 5 years. The Companies Act 2013 has given the limit that at any one time a managing director or whole-time director or manager can be appointed or reappointed for a maximum term of 5 years, not more than 5 years. Secondly, no company shall appoint or employ at the same time a managing director and manager. At the same time, manager and managing director cannot be appointed. Any one can be appointed. Then a person shall be eligible for appointment as MD, managing director, whole-time director or manager only if he satisfies all eligibility requirement as specified in part 1 of schedule 5 of the Companies Act 2013. See, the Companies Act 2013 have schedule number 5. Under that schedule number 5, part 1 will give you number of criteria when a manager, how a manager can be selected. What are the different norms through which a manager can be appointed, can be selected. So a managing director should also comply with the provisions, with the eligibility criteria given in part 1 of schedule 5 of the Companies Act. Approval of the board. Automatically managing director will not be conferred all the substantial powers. It should be given by the approval of the board of directors. The board of directors must approve that this will be the managing director and he will be conferred so and so powers. The terms and conditions of appointment and remuneration payable to the managing director or full-time director or manager shall be approved by the board of directors at a meeting. A meeting of all the board of directors must be conducted. In that meeting, the appointment, remuneration, powers, all these things will be approved by the board of directors. Next one, approval of general meeting. Shareholders, members general meeting will be conducted and there also approval is required. The appointment and remuneration of these managerial persons shall be also be approved by the company by a resolution at the next general meeting. So after appointing the managing director, the next general meeting it should be approved. The members of the company should approve regarding the appointment, remuneration of the managing director. Next one is approval of central government. Sometimes the approval of central government is also required for the appointment of managing director. So when approval is required, if the eligibility criteria of part 1 of schedule 5 are not complied, if the criteria given under part 1 schedule 5, those criteria are not fulfilled, in that case the company has to get the approval from the central government. But every time central government approval is not required. If the criteria given in part 1 schedule 5 is fully complied, there is no need to take the approval from the central government. If the criteria is not fulfilled, criteria given under part 1 schedule 5 are not fulfilled, in that case the approval of the central government is needed for the appointment of MD. Next one is filing of return. Whenever managing director is appointed, the appointment should be intimated to the registrar of companies within 60 days of appointment. That means the company must file a return to the registrar of companies regarding the appointment of managing director within 60 days from his appointment. So in examination, you may be asked a short question regarding who is a managing director, how the managing director will be appointed, explain managing director. So this much discussion is enough regarding managing director. So in this video I have explained you about the remuneration of directors and managing directors. The next topic for management of companies will take up in the next class. So if you are satisfied, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. And give your comments on these videos. Lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, we'll continue the next topic in the next video.